afternoon. So I was moving through the factors relied on by the revenue in support of the proposition that the use of the Borgsten to accommodate offshore workers was not incidental to its other uses. And the second factor relied on by the revenue is the value of the surplus accommodation, which it is said was approximately $50,000 per day, which is about 25% of the daily charter rate. And in our submission, there is no factual basis for that contention. What was found by the FTT in paragraph 172, 3 and 4, was that only a very small part of the daily charter rate was in respect of accommodation, and that the amounts payable by Total in respect of accommodation each month were substantially less than the daily charter rate. So we say on any view the value which the parties placed on the surplus accommodation was very small indeed, and that is even before taking into account the fact that 10 to 15% of Total personnel accommodated on board the Borgsten were in fact working on the Borgsten. And my lord, you asked where you find that in the FTT's decision, and it is in paragraph 143.
Thank you very much.
Now, in our submission, the following additional findings of the FTT also undermine the proposition that the surplus accommodation had real value, and certainly undermine the proposition that it had a value of $50,000 a day. At 85 of the FTT's decision, the FTT found that the provision of accommodation was not a profit centre for DDL. Instead, the charge of $80 per person per day was intended to reflect the marginal additional cost of providing that accommodation. At 92.4, the FTT found that the value of the contract attached predominantly to the provision of the TAD services. And at 93.3, the FTT described as striking the proposed daily rate of $210,000 versus the unit price of $80 for food and accommodation. So we say, in light of the FTT's findings, it is not tenable to suggest that the value of the Borgsten's surplus accommodation was $50,000 per day, or 25% of the daily charter rate.
Where does the $50,000 figure come from?
That is the revenue's skeleton argument, and it is, I believe, an extrapolation from the figures in the numbers that applied in relation to the charter of the Borgholm, which was the Borgsten's sister vessel, which was the Flotel. So
the skeleton refers to an equivalence of $833 per berth per day.
So it 23 sub. Sorry. My own skeleton there. It is, 32 sub 2 of the revenue skeleton.
Yes, I was just wondering where the FTT had accepted that figure.
So the FTT did not accept that figure in relation to the Borgsten. The FTT addresses the Borgholm. I think it's around 62.
Yes, 62 GBUD.
Yeah.
242,000 a day for 270.
Yeah, that's where it comes from. So we say that it is wholly inappropriate to extrapolate those numbers from a charter of a completely different vessel and carry it across to give some sort of value.
Anyhow, I'd like to think that what I am or am not prepared to pay for a night in a hotel doesn't represent my value. And so, I mean, if it's any encouragement to you, I don't place really any weight at all on that argument.
I'm very, very grateful. Thank you. So the third factor relied upon by the revenue is that Total required the additional accommodation for personnel working on board the Dunbar because there were only 60 berths available on the Dunbar itself, whereas the average number of personnel working on the Dunbar during the pre-drilling phase was 80, and the average number during the drilling phase working on board the Dunbar was 60 to 70. And we make 3 points in response to that. First, we say that the fact that the Dunbar had 60 berths of its own means that the majority of offshore workers could have been accommodated on board the Dunbar. And what that demonstrates is that the use of the Borgsten to accommodate offshore workers was largely a matter of preference for Total rather than necessity. And we say, indeed, that chimes with the FTT's observation at paragraph 42, where it says that it was a matter of choice for Total whether to accommodate its personnel on the Dunbar or on the Borgsten. And the second point is that the surplus accommodation enabled Total to carry out its drilling campaign more quickly, which means that the use of the Borgsten to accommodate offshore workers was a matter of efficiency rather than a matter of necessity. And then the third point we make is the one that I've already made, which is but for the TAD services, Total would not have required any additional accommodation. So the TAD services and the accommodation of offshore workers are serving the same purpose, namely the drilling campaign, rather than the accommodation of offshore workers having a separate, freestanding or independent use. The fourth factor on which the revenue rely is that all personnel working on board the Borgsten and the Dunbar required accommodation on one of those vessels. And again, we make the same points essentially in response. The majority working on the Dunbar could have been accommodated on the Dunbar. The reason Total wanted the surplus accommodation was to carry out the drilling campaign more quickly, and in any event, the need to accommodate offshore workers serves the same purpose as the provision of the TAD services. And then the final factor relied upon by the revenue is that even if the additional accommodation requirements of the Dunbar could have been met by a flotel, this would have cost $130,000 per day for the smallest available flotel. Now, a couple of points on that. The FTT did not find as a fact that the additional accommodation requirements of the Dunbar could have been met by a flotel. This was an observation of the Upper Tribunal in paragraph 83 of its decision, and it was an observation made in response to the revenue's claim that the FTT had found as a fact that the use of the Borgsten to accommodate offshore workers was essential. And we say that it's a little surprising to see the revenue embracing that observation here when it is the subject matter of their criticism for the purposes of ground 3. But in any event, it is hard to see how this indicates that the use of the Borgsten to accommodate offshore workers was a separate and independent use. What the FTT did accept in paragraph 62(1) is that where an operator does not need TAD services, it will be likely to charter a flotel. So the reason why the Borgsten was chartered was the need for TAD services, and the need for accommodation of offshore workers was simply a corollary, or certainly a linked component with the provision of those TAD services.
Which paragraph is that? I'm sorry.
That is 62(1). So in our submission, and contrary to what is said in paragraph 34 of the revenue skeleton, none of those factors indicates that the use of the Borgsten to provide accommodation to offshore workers was highly unlikely to be incidental to its use in providing TAD services, or was not a natural consequence of its use in providing TAD services, or was an independent use with substantial importance and value. And in fact, we say the FTT's findings demonstrate just the opposite. So at 82, 92.3 and 171.1, the FTT found that the contract for tender was focused overwhelmingly on the provision of TAD services with very little detail on the provision of accommodation. And this had formed the primary focus of the contractual negotiations. And that was because, as the FTT records at paragraph 154, the primary purpose of the Borgsten was to provide TAD services. At 63 and 173.1, the FTT found that no particular thought was given to the request for accommodation because all support vessels have surplus accommodation, and the expectation is that the operator will be able to make use of that surplus accommodation to accommodate its own personnel. So there was therefore nothing unusual or significant about Total's request. Then at 1713, the FTT found that there was no requirement on Total's part to use the accommodation, still less to use it to accommodate offshore workers, and Total was only required to pay for the accommodation which it used. Then at 92 and 171.4, the FTT found that making surplus accommodation available to offshore workers was immaterial and made minimal difference to DDL, and that what was important was the provision of tender support capacity. At 123 to 125 and 1715, the FTT found that the basis on which DDL agreed to increase the amount of surplus accommodation was that it didn't delay the conversion of the Borgsten into a TSV, and that the additional works were simple and insignificant in the context of the conversion works. At 38 and 1716, the FTT found that the vast majority of the physical space on board the Borgsten, 2 decks, each approximately the size of Wembley football pitch, were used in the provision of TAD services. And then finally, at 45 to 46, 152 to 153, and 171.7, the FTT found that the Borgsten's activities were essentially the same throughout the duration of the charter, in that it was operational and fully staffed in both the pre-drilling and drilling phases, and in a constant state of readiness to provide the TAD services. So at no time was the accommodation of offshore workers a separate and independent use of the Borgsten. Its use to accommodate offshore workers only ever arose in conjunction with and as a consequence of the provision of TAD services. So for all those reasons, we say that the first ground should be dismissed. And I know my learned friend didn't touch on his other 2 grounds, but with your indulgence, may I just briefly address them?
Just before you come to that, I've understood that during the drilling phase, the Borgsten is used to provide mud and water and various other things.
Yes.
So it's an integral part of the 2 platforms.
Of the rig, yes.
I haven't quite understood what support the Borgsten provided during the pre-drilling phase as opposed to the drilling phase.
So during the pre-drilling phase, it essentially provided all of those services, but on a closed loop. So it ran the mud and the compressed air and the water and the cement, but it went round in a loop rather than going into the well, if I can put it that way. So it was running all of those services, analysing.
Tell me where the FTT deals with
that.
Thank you.
A couple of points actually. 45
Yes. 46.
Yeah, 45, 46. And I think later on in the summary of Fame's evidence, I believe.
Well, 45 and 46 is,
45 and
is
46
clear enough.
do it,
Yes, yes. Thank you very much.
So ground 2 is that the Upper Tribunal focused too much on the terms of the Total contract and on the actual use of the Borgsten rather than the uses to which one might reasonably suppose the Borgsten was likely to be put. And in our submission there is no substance to this ground. First, we say it is obvious from their decisions that both the Upper Tribunal and the FTT were fully cognizant of the nature of the statutory test. In 168 and 169 of the FTT's decision, the FTT explains that subsection 3 requires them to assess whether it is reasonable to suppose that the Borgsten's use to accommodate offshore workers was unlikely to be more than incidental to its other uses. And it accepts that the statutory test is not concerned with actual use, although actual use may be relevant in assessing what it is reasonable to suppose is likely and unlikely. In paragraph 87 of the Upper Tribunal's decision, it endorses the FTT's approach and describes the statutory test as a multifactorial assessment. And in paragraph 88, it explains that the weight to be attributed to any particular facts is ultimately a matter for the FTT. In 37 of the revenue skeleton, they criticise the final sentence of paragraph 76 of the Upper Tribunal's decision, where the Upper Tribunal says whether or not something is incidental depends on all the facts, and they suggest that the Upper Tribunal failed to appreciate that what matters for the purposes of 356 LA3 is not whether use to accommodate offshore workers is incidental, but whether it is reasonable to suppose that the Borgsten's use was unlikely to be more than incidental to another likely use. Now, in our submission, it cannot tenably be suggested that the Upper Tribunal misunderstood the statutory test because it repeatedly refers to its terms, and we set out the references, all of the references in paragraph 27 of our skeleton. In our submission, what the Upper Tribunal is addressing there in paragraph 76 is the question of whether something which is desirable, sought after, or important might nonetheless be described as incidental. It is plainly not saying the question posed is whether the use of the Borgsten to accommodate offshore workers is incidental to its other likely uses.
Can I ask, I'll ask Mr. Hewitt this. The statutory question clearly envisages somebody asking the question, is it likely that it will be used, etc., etc. And that prompts the question, when do you have to ask that and answer that question? And he said at the beginning of each accounting period, so in this case on the 1st of April 2014 and the 1st of January 2015. Do you agree with that, or do you say that's wrong?
You certainly have to ask it in respect of each accounting period. Precisely when you ask it, I suppose I would be more inclined to go with the end of the accounting period when you are then completing your tax return and sending it into the revenue.
But it seems an odd question to ask in December. Is this vessel likely to be used for something during 2014? Because you know by then what it has been used for.
Absolutely, and I was going to come on to this, in fact, this very point right
okay.
now.
Okay.
So in paragraph 38 of the revenue skeleton, they say the question of likelihood must be determined by reference to the physical state of the asset and the likely uses to which it might be put, rather than by reference to what actually happened. And I say two things about that. I say first, the reason why the test operates by reference to what it is reasonable to suppose the vessel's likely uses will be is not to detach the inquiry from all reality as to what has happened, but simply because the taxpayer may not know exactly how much use is attributable to the accommodation of offshore workers. For example, it may not know exactly how many of the operator's personnel are working on board the other vessel. Indeed, it may not know how often its own personnel go to work on board that other vessel. So framing the test in terms of what it is reasonable to suppose the likely uses will be, in our submission, is a pragmatic solution to the potential compliance difficulties that might crop up if you are concerned solely with actual use. But in our submission, framing the test in that way does not mean that actual use is irrelevant. Actual use, as the FTT observes in paragraph 169, is relevant in assessing what it is reasonable to suppose the likely uses will be.
So I understood this correctly. Your submission is that what the taxpayer should do is look back at the end of 2014 and say, well, I know what's happened, but insofar as I don't know precisely how much of that is accommodation of offshore workers, I can form a view as to how likely it is.
Yes.
Yes.
And we say that question must be asked in relation to each accounting period. So it is possible that...
Well, it's theoretically possible that you could have a different use in
Yes.
the next accounting period, but it's not suggested here.
Exactly.
Well, there was a pre-drilling phase which came to an end sometime in 2015, and then a drilling phase. But on the facts, I don't think the use was any different. Is that right?
It wasn't, no, in these circumstances. But the reason why actually in this particular case the actual use is relevant is that we are concerned here with the accounting periods ending December 2014 and 2015. And the charter commenced in February 2013. So in our submission, in assessing what it is reasonable to suppose the likely uses of the Borgsten will be during those accounting periods, it's appropriate to have regard to what has gone before and to the actual use to which the Borgsten has been put since the commencement of that charter.
So does it matter whether one looks at it in April 2014 or December 2014? Because at either date, as you say, the contract's in place and it has been operating. It's been alongside for, I think, a year or more.
Yeah.
So whether what you're doing in April 2014 is looking forward for the next 9 months, saying what's the likely use of it in the next 9 months, or whether in December you're looking back and saying what has been the use, filling in any gaps by what was it likely to have been, you should get the same answer, which is, well, this is how it has been operated in 2013 and up until the end of March 2014, and there's no reason to suppose it's going to be any different.
Yes, exactly.
So maybe we don't actually need to decide.
I don't think you do, but it's just to give I'm just trying to offer an explanation as to why the statutory language is couched in those rather unusual terms about what it is reasonable to suppose.
But are you also
likely.
are you in agreement with Mr. Hewitt that in this case it doesn't really matter?
No.
The fact there's a long run up to the delivery, as it were, is in this case doesn't really alter the outcome.
No, and what happened and what was likely to happen.
Yes.
I accept.
And also,
what you're saying.
following from my Lord's questions, which had to do with this case, obviously any interpretation of this section has also got to work for somebody who hasn't bought the kit, hasn't started drilling, but is seeking to plan efficiently in the tax sense for a future purchase. So in this case, as it were, everybody had the advantage of quite a lot having happened before the tax year in question.
Well, there was no further planning to do around it.
But
It was already in situ.
it was all set in, and
Yes.
the only question was whether you were caught by this or not.
Yes.
Whereas the interpretation has to work equally for people who are seeking to plan for these sorts of events.
Yes, absolutely. Yeah.
Well, then it might make a difference for somebody else, because in April 2014 they might not have yet got their contracts in place, but they can see that they're about to place a contract. Then it does make a difference whether what you do is at the beginning of the accounting period look forward to what you think's likely to happen, or what, rather not what you think's likely to happen, what an objective observer might reasonably suppose likely to happen, or whether you look back and see what has happened, because you could envisage a situation in which it was reasonable to suppose it was likely to be used for accommodation, but for unexpected reasons, actually it never was.
Yeah, I mean, it would be quite unusual to have to take a view at the beginning of an accounting period as to what was going to transpire during that accounting period, and once you've taken a view, as long as it's reasonable, then whatever happens after it is completely irrelevant. I would say sort of naturally, if you're at the point at which you're accounting, i.e. the end of your accounting period, when you're filling in your tax return, you're asking yourself, that's the point at which the question becomes relevant.
Yes, I see. Thank you.
So we say whether it was reasonable to suppose that the Borgsten's use to accommodate offshore workers was unlikely to be more than incidental to its other uses is a multifactorial inquiry, and taking on board all relevant considerations, including not only the physical state of the asset, but the terms of the tender, the nature of the TAD services, the process of agreeing and the terms of the contract itself, the actual and historic use of the vessel, market practices and market norms, the parties' understanding, and anything else that might be informative. So in our submission, the FTT was both entitled and correct to take the wide-ranging approach to the facts that it did. In paragraph 87 of the Upper Tribunal's decision, it describes those findings of fact as careful and detailed, and we would respectfully agree. The Revenue's final point on this ground, in paragraph 39 of their skeleton, they say that where use to accommodate offshore workers is desirable, sought after, or important, and there is a substantial surplus accommodation, then it's unlikely in those circumstances to be more than incidental to its other likely uses. And I believe I've already addressed you on that point, but in summary, we say something can be desirable, sought after, or important, and still incidental. And the mere fact that a vessel has surplus accommodation, even substantial amounts of surplus accommodation, does not mean that its use to accommodate offshore workers is likely to be more than incidental. So that's what we say about the second ground. The third ground of appeal is that the use of the Borgsten was essential, and I can deal with this briefly. The fact that the FTT found at paragraph 1271 that all those working on board the Borgsten and the Dunbar required accommodation on one of those vessels does not mean that the use of the Borgsten to accommodate offshore workers was unlikely to be more than incidental to its other uses. And I've already made the point that it was largely a matter of preference rather than necessity. I've already made the point that it was for reasons of efficiency rather than necessity. But it's also important to note that DDL was not obliged to accept the request for additional surplus accommodation. That's the FTT paragraph 113. So it was entirely at the discretion of DDL whether or not to accept that request, and the basis on which it did accept that request was that it didn't delay the conversion of the Borgsten into a TSV and the commencement of the provision of TAD services. And on our submission, that would tend to suggest that the additional accommodation was not an essential component. Thirdly, we say it overstates the position to say, as the Revenue do in paragraph 41, that operations on the Dunbar could not have gone ahead without the accommodation on the Borgsten. They certainly could not have gone ahead as quickly, but there is no finding of fact that they could not have gone ahead at all without the Borgsten's accommodation. Fourthly, we say it was not essential for offshore workers to be accommodated on board the Borgsten. It was certainly convenient, it was certainly cost effective. But as the Upper Tribunal observes in paragraph 83, there was no reason in principle why offshore workers could not have been accommodated on a flotel. And finally, we say even if it was essential, it was nevertheless incidental, in just the same way as the emergency landing in Robson and Dixon was essential yet incidental. So those are all my submissions, unless you have any further questions.
Could we just finally go back to page 3 of the authorities bundle and the section itself?
Yeah.
I'm looking at subsection 3. A lot of attention has been taken in relation to the words more than incidental to, and the run-up to them, which we've established, I think, as common ground. It doesn't really matter for our particular case. But could we just focus the following words for a moment? Incidental to another use or uses to which the asset is likely to be put. Now, I've understood your submission to amount to this, that because we're all there to drill oil, that is a use of the asset. And that really is how you put it, isn't it? You've put it in a number of different ways, namely it's the same purpose, it's the drilling campaign, but the accommodated folk and the activities on the Borg rig are there in support of the same purpose.
Objective, yes.
Objective.
Yes.
Now, speaking for myself, that's not what this requires. That what we're talking about here, I'm suggesting to you so you can deal with it, is that where we're talking about another use or other uses to which the asset is likely to be put, we're talking about the things that are referred to in FTT 26. The use of the platform, the secondary platform, is to do all of those things in support of the Dunbar. But what you're doing, I would suggest, is you're eliding that very clear statutory requirement into something different, which is just we happen to be here for the same campaign. Now, there's a distinction between those two, isn't there?
Well, it depends. Firstly, it depends whether incidental to requires a causal link. So that's the first question. My answer is it doesn't. What the words incidental to require is a relationship between one thing and another thing. That may be a causal relationship, but it may not be a causal relationship.
Well, we're going back to incidental to, and this is your answer, I understand it, but
well,
will you come at some point to what is meant by a use of the asset?
Yes, and I've identified 4 uses of the asset. TAD services.
Yes.
Sorry, three uses of the asset. TAD services, accommodation of, it is 4. TAD services, accommodation of Borgsten's own crew, accommodation of Total crew who are working on board the Borgsten, and accommodation of offshore workers. Those are the 4 uses of the Borgsten. So the question is whether the accommodation of offshore workers is incidental to those other uses. And if incidental to requires a relationship, which is my case, that provided you can say that use of the Borgsten arises in connection with those other uses, which in my submission it plainly does, they are all, that it is not something that just simply arises of its own accord. It's clearly related to then that's sufficient to get me home. If you say, well, no, it must have a causal, there must be a causal link. One must be the consequence of the other. One must be a result of. Then it depends what you mean by consequence or result. Does it have to be a direct consequence? Could it not be an indirect consequence of it? So, but for the TAD services, there would be no drilling campaign. But for the drilling campaign, there would be no offshore workers. So it's plainly indirectly connected to the provision of TAD services. But I accept the point that you make, which is, do the TAD services themselves require additional workers to be on board the Dunbar? I'm not sure I would describe it in that way. No, I mean, the TAD services require that there to be offshore workers, because that is what gives rise to that is what the TAD services give rise to. They give rise to the drilling campaign. They facilitate it, and we know that those offshore workers are in the number of 80, and 20 of those will have to be accommodated on board the Borgsten.
But at all events, I follow the submission, but would you accept that we have to consider quite carefully what is meant here by the expression the use or uses to which the asset is likely to be put?
Absolutely.
And what that means, and whether it's the broader version that you're arguing for, which is drill oil, the common purpose.
But I'm responding to the revenues case, which is based on Robson and Dixon. I say you have to look at the uses. I'm not suggesting otherwise. That the revenues case is, for something to be described as incidental to something else, it can only serve the same purpose. And I'm responding to that and saying, well, they do serve the same purpose, which is the drilling campaign. But what is interesting is, if you look at Robson and Dixon, the Vice-Chancellor isn't looking at purposes. If the Vice-Chancellor was looking at purposes, you might say the answer would have been different. The UK duties were not incidental to the foreign duties, but that was nothing to do with purposes. The UK duties served the same purpose as the foreign duties, but they were not incidental to them. Likewise, the emergency landing, the duty of bringing down the plane in an emergency, was incidental to the foreign duties, even though they serve quite clearly different purposes.
That's very helpful. Anything else? Thank you very much indeed, Ms. Shaw. Yes, is there any reply, Mr. Yurt?
Yes, perhaps I can reply to quite a number of these points by reference to Robson and Dixon, because I think the answer to a number of them is actually in Robson and Dixon just then. Could we start with whether this is a narrow construction? And I say, although I understand my learned friend using that expression forensically, what we're not contending for a narrow construction. We're contending for, as the Vice-Chancellor said, the natural construction of the words. That's exactly what he said on page 14 of Robson and Dixon. Effect must be given to the natural meaning of those words. So we're contending for the natural meaning. As regards the final point my learned friend was making about them being together in the services together provide the drilling services in some way, a very similar point was raised and rejected by the Vice-Chancellor on page 16. He said, just under letter A, it's tempting to say that all the duties performed by a pilot are incidental to the approach to the purpose of transporting passengers from one place to another, but that approach clearly would not help here. What has to be shown is that the particular duties in the United Kingdom are incidental to the performance of other particular duties outside the United Kingdom. And we would submit that's exactly the approach that you should adopt to this provision. Looking at the use of the accommodation and whether it's incidental to the uses in paragraph 26 uses, of the Borgsten.
Well, what do you may be about to come on to deal with the point that was just under discussion, which is, what are those uses?
We
Are
say,
they the paragraph 26 uses?
that's what we say.
And why are they not wider in the way that Ms. Shaw argues, namely that it's the whole campaign?
Well, that's, as I understand it, that's a similar point. To the
It's
point
the same.
that the Vice-Chancellor is making here. You could talk in general terms that all the flights they use are incidental to the purpose of transporting passengers in a sort of general way, but that's not the statutory test.
Well, it is true, as a matter of fact, is it not, that everything that was done on the Borgsten, including accommodating the Dunbar workers, was directed towards the end of extracting oil from underneath the sea and
Yes.
selling it. I mean, it's not being done for any other reason.
That's absolutely true. But we are asking the question: is the use of accommodation incidental to the uses, say the paragraph 26 uses, in the sense that does the use of accommodation for the Dunbar workers further the uses, the 26 uses? So it doesn't. You don't get to looking at the wider the drilling campaign in answering that question.
Well, this is in a sense an
That's-
anterior point to the question of what it needs to be incidental. I mean, incidental, I understand on your case, means there's got to be a link.
Yes.
But it would, having established that in one's mind, the argument against you would fail at the point, you would say, of what uses one is actually considering, because nobody's suggesting that these workers were helping helping with the support services or anything of that sort.
No, and you have to look at I mean, it's important that you're focusing on the services, the uses to which the auxiliary vessel is being put.
Yes, but uses and purposes are not the same thing.
No, I've never.
I mean, but that's
I've never said they
distinction.
are. Yes, no, and I agree. I don't know where that's come from. That maybe my learned friends gloss on it, but we're not looking at purposes. We're looking at whether one use is incidental to another use.
Yes. So, yes.
As I understood what Ms. Shaw was saying, she accepted, I think, that the use to accommodate offshore workers has to be incidental to the other uses to which the Borgsten is put, and she listed them, the TAD services and the accommodation of the Borgsten crew and the total personnel who are working on Borgsten. But she said it is incidental to those things because they are all directed towards the same end.
But that's because she's using incidental in a completely unnatural, non-English sense. They're not incidental because of that. One use is incidental to another if as I say, that it furthers the other use. It's not incidental.
Not that the two of them further the same purpose.
They happen to be furthering the same purpose.
Yes, thank you.
That wouldn't be enough. Otherwise, all sorts of uses would be incidental to each other. But that's not a natural use of the word incidental to.
Well, you wouldn't catch the accommodation of anybody in a support vessel, because I mean they're all out there to drill oil.
Yes,
In the final analysis.
that would be right. Yeah, so there wouldn't be any circumstance in which they would be.
Well, unless it was just a flotel, which
Unless it was
was
just a flotel.
only used for accommodation.
Yes, I guess so. But then that brings me. I suppose that brings me on to the purpose of point, which is that as far as I could see, there was no suggestion as to what the purpose of subsection 3 was in my learner friend's submissions. On my learner friend's case, that is the effect. The effect seems to be to mean that when you have accommodation for workers who are working on the rigs drilling, which is one of the things that the legislation is trying to target, as long as you've got something else being done on the vessel, and you can manage to say that it's incidental to that, then you escape the restriction, and that can be a sensible statutory purpose. We would submit the purpose is the purpose that I identified, which is to take out situations where the vessel itself, its crew, some of them are offshore workers, and therefore could be caught by the the provision otherwise. And that would be a perfectly rational purpose for Parliament to have, to say, well, you may be technically an offshore worker because you happen to, we've defined offshore workers as someone who work on a rig, but you're actually providing the TAD services or the support services, and therefore your accommodation shouldn't disqualify your accommodation alone shouldn't disqualify the vessel. But this construction means that we're widening it out to accommodation for workers who are drilling.
There's no provision in the legislation for apportioning the higher cap between such part of the rent as could be attributable to accommodation. So if you're right, then it caps the entirety of the rent.
It caps the rent, yes. Of course, we're only talking about, but we are talking about capping it at what is regarded as a reasonable amount. You're not losing relief altogether.
No, 7.5% of the capital value.
Yeah, yeah. Rather than 90% or whatever, the vast amounts of rent that are paid to the offshore countries. So that's, you're right, but that's because Parliament's made a choice to have a relatively simpler system anyway. Because an apportionment would be enormously complicated if you tried to.
Well, we can see in this case that if you tried to divide the 200,000 into how much was payable for this and how much was payable for that, you could argue.
You could argue that forever.
Yes.
Yeah. Yes. So all that's been done is ensure that if there is accommodation, essentially for workers on the exploration and drilling, then that will generally be caught.
Do you accept there might be a de minimis exception?
I think, yes, I'm sure that's right, and as I said, the likely test. This is why the likely test is there, though. I think you were discussing that with my learned friend. One of the reasons why it's there is it means that you don't say, well, just because there was one or two, emergencies or whatever, and they had to be accommodated. Say there was a bout of Legionnaire's disease or something. Or COVID on the rig, and a lot of them decamped to the support vessel for a while. That wouldn't disqualify them because it wouldn't be likely that would happen.
Is it fair to say that the Vice Chancellor saw de minimis as a separate point?
I think he did, yes, but
which suggests that if you are analogising with Robson and Dixon, then there's a de minimis let out. But there would also be a sort of minor use let out.
Well, can we just look at that more closely? The example about the plane having to land in an emergency, that is, of course, a flight, an international flight we're talking about. So what he's talking about is a pilot who is actually working offshore. It's an offshore journey, but it has to be by an emergency. It has to land at Heathrow or something because there's I don't know, someone on the plane that's causing trouble or something, or some kind of mechanical fault, and it has to land. So you could say that is incidental to the offshore activities because it's part of your offshore job. If you're flying a plane from Holland to America and there is an emergency, you have to land somewhere. It's actually part of that. So it's incidental in that sense. That's what I think he was thinking there. Whereas the de minimis, if there's only one day or something, I think that's different.
Yeah.
That's just a
So
true
just,
de minimis.
just coming back to the tests you were outlining this morning, in the event of having to land because of the weather conditions, you say that landing is carried out to further the overall purpose of performance of the offshore duties.
I would say it was. I think it was actually, maybe even more than that, it actually is part of the.
Yes, I see.
It's actually part of them. Maybe you don't even need to get to incidental, but you certainly would be. You do.
I mean, they are in theory, as you say, separate things because there was no suggestion for the one day in 1961 to 2 when Captain Roberts did land in England, which was accepted to be de minimis, that was an emergency. It was just he only did it once, and it's just a sort of instinctive feeling he shouldn't be held resident when he's only been here once.
I think that's right. That's right.
And you could have an analogy here where it could be likely, even if you are right, you look forward to the year, it could be likely that there will be some occasions during the year when one or two offshore workers will be accommodated.
But that may be
But it may be
Yeah.
But we're not in that territory with
No, we're
these
not.
numbers.
No. No. Yes. So, and as regards the argument that this was a matter of evaluative judgment for the tribunal, well, of course, clearly, before they carry out their evaluative function, you've got to decide what the nature of the exercise is. And if the nature of the exercise is as we say it is, then it doesn't. Their whole evaluative judgment has been mistaken. Really.
This is not an Edwards and Bairstow challenge. It's a challenge saying they've adopted the wrong approach. Yes.
And that's again in Robson and Dixon. He makes a sort of similar point right at the end, where he says the decision of the commissioners is one of fact. The counsel for the Crown, quite rightly, I think, has not tried to make much of that point. Here, the question is really one of the construction of Section 11. So,
yeah.
That's right.
Yes.
Thank you. I think that's everything.
Well, thank you both and those who support you. Interesting argument, and we'll take time to consider it and let you have our judgments in due course when we can. You will obviously know the procedure. Please offer any corrections, create an order that reflects our decision. If you can't agree anything, then short submissions, and we'll decide those on paper. And the judgments will be handed down electronically, so we won't need to trouble you to return for that. But thank you all very much indeed.
Thank you.